Hello, everybody. You have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Hello, everybody. We're back with another in the Dassey computer saga. This is Kathleen Zellner's reply to the state's response to her original motion to compel the state to turn over its most recent its forensic evidence regarding the most recent forensic examination of the Dassey computer. She makes it the few things that she goes through here. I mean, number one, the state keeps saying that she offers no clear narrative or plausible scenario of how Bobby could have done this, whatever. Well, she does that here. And I would point out she has done it before, at least, but it wasn't as fleshed out as this one is because so much stuff keeps coming out that keeps falling into line. But it wasn't as fleshed out as this one. But she gives a scenario. She refutes that they are trying to make O'Brien apply here as case law. But she's asking for an in-camera review, so it's a little different. And O'Brien doesn't quite, the O'Brien standard doesn't really apply. Various things here. Like I said, we're going to go ahead and get into it. But one thing I want to say is with everybody here, with all this stuff that's getting talked about, remember that everybody has their presumption of innocence. It's, for me, it's important because I don't feel like I can talk about how Stephen's presumption of innocence was taken from him if I don't respect the presumption of innocence of others. See, my whole beef with Manitowoc and Calumet the whole time is that if the presumption of innocence was for them, they want it, they expect it. But if it's for somebody else who they don't care about, then it means nothing. If it means nothing for one person, it effectively begins to mean nothing for everybody. So, just wanted to point that out at the beginning here. This is all pretty interesting stuff. The one thing I want to show you right now, here, right before we get into the documents, so that you don't find yourself, like me, going, what the heck's an in-camera review? I don't want that to distract you from what's being talked about. So I'm going to show you right now what an in-camera review is, so that we already got that out of the way, and then we'll move into the first document. This is just to give people an idea of what in-camera review is, because it's going to be talked about here in this motion. It's what Zellner is asking for regarding the new information, the re-examination of the computer, where they are examining basically the 280 days leading up to trial, because the first examination was only until April 26th of 2006. From April 27th to all the way up to trial February of 2007, that is the information that they went in and were looking at in the 2017 review of it. So that's why they were going in there, and this is why Zellner's saying that she should be able to see it. She's making arguments that, according to questions that they asked Bobby, that there's without a doubt something on there that's of consequence, and so she wants definitely the judge to do what's called the in-camera review here, to determine whether or not the defense has a right to see that as discovery. Because in the United States courts, an in-camera review describes a process or procedure where a judge privately looks at confidential, sensitive, or private information to determine what, if any, information may be used by a party or made public. Note, the judge has complete authority on in-camera review. So it's completely up to the judge. And this reminds me of, like, with the OJ case, Judge Ito, when Faye Resnick wrote her book, that sensational book about Nicole and her and all that and whatever. Judge Ito had to go through that, and he had to kind of determine what he wanted allowed into his courtroom and whatnot. To an even bigger extent, with the OJ trial, when Johnny Cochran and F. Lee Bailey were able to go get the interview tapes of Mark Furman talking to that lady who was writing a story, and where he was just describing all the horrific acts and things like that he was talking about, and when he was using the word, the N word, and all the things that he was doing, after he had so emphatically denied them in his first time on the stand. But anyways, when Judge Ito was going through all that, he only allowed like a handful of the things that were said in there to be used. And if you remember, that was pretty crazy. Johnny Cochran himself got all pretty angry about that. But the point is, they were able to by what Judge Ito was able to give them, they were able to impeach Mark Furman's testimony. So, it's going to be interesting, but that's kind of, from what I can see here, that's kind of what an in-camera review is, kind of what Judge Ito was having to do with those two things in the OJ trial. Okay, so here we have Kathleen Zellner basically laying it out, the scenario for Bobby that she has come up with. Keep in mind, Bobby, Scott, even Ryan, all are entitled to their assumption of innocence, like Stephen should have been, of course. But the state keeps saying that Kathleen Zellner hasn't offered any scenario or anything that how Bobby did this or whatever. And the funny thing about that statement, before I start this, is that I remember what I'm about to read here for you. I remember reading a lot of this in her original motion for post-conviction relief, the 1,000-page thing back in June of 2017. I remember hearing much of this laid out then, only that now she's had other new facts surface since then, and she has now added those in to fill in certain gaps here in her scenario. So it just shows a progression of things continuing to fall into line in terms of this. Take it for what it's worth, but that's really what appears to be happening. So, even if the court refuses to apply collateral estoppel, there is an abundance of evidence that meets the opportunity and direct connection requirements. The following evidence fits within the contours of the known facts of the case and cannot be readily disproven. Mr. Avery does not have to actually prove that Bobby committed the crime, as long as his theory is based on evidence beyond a possible ground of suspicion. The evidence supporting that Bobby was a viable third-party suspect and had a realistic opportunity to engineer the crime is as follows. Bobby had developed an obsession with Miss Halbach, and on a number of occasions watched her from his residence and commented on her visits the next day. Because Bobby's obsessive and compulsive preoccupation with viewing violent pornography of women, many of whom resembled Miss Halbach, he developed violent sexual fantasies about her. The Dassey computer also contained images of unconscious or deceased young females who resembled Miss Halbach. Mr. Avery did not leave the Dassey phone number with AutoTrader because he was waiting for a return call to his cell phone or landline to confirm the appointment. Right? Makes sense, because he was the one that was actually there that day. Barb was actually at work. Right? So it makes sense that he would give a number that they could reach him who was there to confirm it. Because Bobby was awake, he would have heard the voice message left by Miss Halbach on the Dassey answering machine at 11:43 a.m. Someone other than Mr. Avery or AutoTrader, who knew that Ms. Halbach did not have the Dassey address provided her with the Dassey address prior to 2:27 p.m. when she told Don Pliska that she was on her way to the Avery property. Bobby was the only person who could have listened to Ms. Halbach's voice message to the Dassey residence at 11:43 a.m. and known that Ms. Halbach did not have an address for the appointment. Bobby lied to the police when he denied knowing that on October 31st, 2005, Ms. Halbach was coming to the property. On October 31st of 2005, Bobby told police that he saw Ms. Halbach by her vehicle for approximately 10 seconds. However, Bobby was able to describe Ms. Halbach's clothing, physique, and hairstyle, indicating that he had more direct contact with Ms. Halbach than simply seeing her out of his windows for 10 seconds. Bobby's computer was in use on October 31st of 2005, which impeaches his trial testimony that he was asleep from 6:30 a.m. to 2 p.m. The computer was used to access the internet on October 31st, 2005. At 6:05 a.m., at 6:28 a.m., at 6:31 a.m., at 7 a.m., at 9:33 a.m., at 10:09 a.m., at 1:08 p.m., and at 1:51 p.m. The Dassey computer internet browsing data indicates that 22 pornographic searches were made on October 31st of 2005. As Miss Halbach left the property, Bobby followed her in his Blazer. Ms. Halbach's cell phone records indicate that she had left the Avery property by 2:41 p.m. and headed west on South 147 to South CTHQ. Sorry, I don't know how they call their streets there in Wisconsin. I'm a bit of a dullard when it comes to that. Those street names seem odd to me. It was established at trial that Ms. Halbach frequently did hustle shots. Because Bobby lied about following Miss Halbach from the Avery property, he most likely is the person who waved her down for a hustle shot. Miss Halbach was in the area of Cuss Road, so it is a reasonable inference that she stopped her vehicle for the hustle shot at Cuss Road cul-de-sac. Miss Halbach opened the rear cargo door of her RAV4 to obtain her camera for the photograph. The blood splatter on the inside of the RAV4 cargo door demonstrates that a struggle ensued between Miss Halbach and her attacker. Specifically, the blood spatter indicates that the perpetrator knocked her to the ground and struck her repeatedly with a rock or other hard object while she was lying next to the rear tire of the driver's side. Rear tire on the RAV4. The dog alerts indicate that Miss Halbach was in the area of the suspected burial site for a period of time where she may have been assaulted. The hair bloodstain patterns on the inside of the rear cargo area of the RAV4 were created by Miss Halbach being placed in the rear cargo area of the RAV4 and her injured head bouncing on the inside panel as the RAV4 was moving. So what that's saying is the explanation for the way that the blood appears on that little plastic where they found the bits of dried blood with her hair in it and stuff over there where everybody believes her head was laying. So what they're saying here about the blood spatter is that the way that blood and everything, the pattern of it indicates that Teresa's head was in there while she was still bleeding, and that car was going down those bumpy dirt roads. Trust me, I can tell you, those roads there, the ones that are dirt roads and stuff, it's not a smooth ride like it is on a city or a county highway. Trust me. So there would have probably been some bumping around. So they're saying that blood spatter pattern is created because Miss Halbach was in the car while it was being moved to a secondary site. Now I just find that interesting and thought it needed to be called out a little bit. Bobby testified that he saw Miss Halbach taking photographs at approximately 2:30 p.m. Mr. Avery claims that Miss Halbach left the property shortly thereafter. Brian Dassey also claims that Bobby saw Miss Halbach leave the property. It is reasonable inference that Miss Halbach and her vehicle were brought back to Avery Salvage after she left the property the first time. It is a reasonable inference that Miss Halbach was shot by Bobby's .22 LR because Scott Taddick, Mr. Taddick, attempted to sell Bobby's .22 LR the next week to a fellow employee in the Wisconsin aluminum foundry. The Dassey garage was never luminoled or checked for forensic evidence of any type. However, blood, which was never tested, was found between the Dassey garage and residence. According to John Larriquin, a propane truck driver who was on the Avery property on October 31st, 2005, a vehicle similar to Miss Halbach's RAV4 drove past him at 3:45 to 3:50 p.m. Mr. Larriquin was uncertain whether the driver was male or female, or which direction the vehicle turned in as it exited the Avery property. According to Blaine, he observed Bobby's driving a green vehicle east on South 147 between 3:45 and 3:50 p.m. On October 31st, 2005, and then on October 31st, 2005, a vehicle matching Miss Halbach's RAV4 description was observed parked by a tree at the old dam east of the Avery salvage yard on South 147 before sunset by witness Paul Burdick. On November 2nd and 3rd, 2005, a vehicle matching Miss Halbach's RAV4's description was observed parked in the same location at the old dam by witness Kevin Ramlow. The distance from the old dam to the salvage yard is 1.7 miles, a 20 to 30 minute walk at most. Miss Halbach's electronic devices were burned on October 31st, 2005 in the Dassey burn barrel behind the Dassey residence at approximately 4:30 to 5 o'clock p.m. And that fire was observed by Josh Verdant from his property. It is a reasonable inference that Miss Halbach was dismembered in the Dassey garage because of Bobby's attempt to conceal evidence by hanging a deer in the Dassey garage and lying about the time frame at which that happened. And then checking the interviews with Barbianda and stuff like that to hear that. On October 31st, 2005, Miss Halbach's body was put in the Dassey burn barrel and transported to the Manitowoc County gravel pit after sunset. According to Mr. Avery, Bobby was the only Dassey or Avery family member who frequently hunted in the Manitowoc gravel pit. Was very familiar with the terrain and burned a deer in his barrel. Miss Halbach's body was burned in the Dassey burn barrel, and the odor was detected by Travis Grohl as he was working on CTHQ after sunset. On October 31st, 2005, Miss Halbach's body was put into the Dassey burn barrel and transported to the Manitowoc County gravel pit after sunset. According to Mr. Avery, Bobby was the only Dassey or Avery family member who frequently hunted in the Manitowoc gravel pit, was very familiar with the terrain, and burned deer in his burn barrel. Miss Halbach's body was burned in the Dassey burn barrel, and the odor was detected by Travis Grohl as he was working on CTHQ after sunset. On October 31st of 2005, Bobby was 2 hours late leaving for work from the Avery property. He did not leave for work until 11:30 p.m. After Miss Halbach was initially burned on October 31st, 2005, 60% of her skeleton and most of her teeth were removed from the Manitowoc County gravel pit and burned elsewhere. Some of her bones were inadvertently dropped on the ground in 3 locations in the Manitowoc gravel pit. The burn barrel was returned to the Dassey residence, leaving some of Miss Halbach's bones in the burn barrel. On November 4th, or in the early morning hours of November 5th, 2005, Bobby planted some of Miss Halbach's bones in Mr. Avery's burn pit. Mr. Avery's dog, Bear, knew him and did not bark. Bobby tipped the Dassey burn barrel into Mr. Avery's burn pit, planting some of the bones, but inadvertently left the remainder in the bottom of the Dassey burn barrel. The bone mass in the Dassey burn barrel and Mr. Avery's burn pit totaled 40% of Miss Halbach's total bone mass. On November 3rd, 2005, Mr. Avery told Bobby that Sergeant Andrew Colburn's visit with the Avery salvage yard regarding Miss Halbach's disappearance. Bobby observed that Mr. Avery's finger was cut and bleeding. When Mr. Avery left the property to go to Menards, Bobby entered Mr. Avery's trailer and wiped blood from the Avery sink. He transported that blood to the RAV4 and selectively dripped the blood into Miss Halbach's vehicle in order to frame Mr. Avery for the murder. Bobby was the only person who could have planted Mr. Avery's blood in the RAV4 because he was the only person home on November 3rd, 2005, when Mr. Avery's finger started bleeding again, and who had access to Mr. Avery's blood in the sink during the crucial time period before the blood completely coagulated. It could only have been the taillights from Bobby's vehicle that Mr. Avery saw by his trailer, because no one else could have driven to Mr. Avery's trailer in that time frame. The court in Wilson held that if the defense theory is that a third party framed the defendant, then the defense might show opportunity by demonstrating the third party's access to the items supposedly used in the frame-up. Bobby is the only family member in the Avery property who was present and had access to the blood dripped in Mr. Avery's sink on November 3rd of 2005. So, and that is, I'm starting to have a little bit more tolerance for this theory about somebody getting into, Stephen's sink and getting some of that blood, because, like I said, because of the way that I see it planted in the RAV4, where it's basically like these it's like 6 like drops, kind of like, and they're like very small. And then you have where it looks like it was smeared on over by the ignition, like it was smeared on with something because it was running out and they were trying to get some more of Stephen's DNA, in an obvious place. Kind of that. I mean, that's just the way it looks. It looks so obvious to me that that's the way that blood looks in the RAV4. Explains why there's no fingerprints and all that various sort of stuff. But so yeah, I found that particular paragraph there interesting. Thought I'd point that little point that I wanted to make out. And then Bobby misinterpreted the comments that were made in a conversation between Mr. Avery and Bobby. The conversation did not occur in the Dassey garage. The conversation was initiated by Bobby, who asked Mr. Avery if he had Miss Halbach hidden somewhere. Mr. Avery thought Bobby was joking and stated, "Under my bed." Mr. Avery did not start this conversation. When Mr. Avery reviewed Bobby's recent interview, he thought it was suspicious that Bobby was referring to Miss Halbach as deceased, since at that point on November 4th, 2005, everyone thought that she was still missing, and Mr. Avery did not know she had been murdered. So, yeah, Bobby had scratches on his upper back in close proximity to the time of the murder that were consistent with human fingernails. According to the current post-conviction counsel's forensic pathologist, Larry Bloom, the scratches on Bobby's back were not caused by a Labrador puppy and are consistent with human fingernails scratching Bobby's back. In Bobby's 2017 re-interview by the police, he denied that the computer was in his bedroom, even though the crime scene video shows the computer is in his bedroom. It certainly doesn't work in your favor when you actually say something that can actually be proven with video that everybody can see. You keep making statements like that and you're going to be in a lot of trouble. But so, as I said, the state has been asking, or has been claiming or harping on the fact that Kathleen Zellner offers no possible theory or whatever, this and that. Well, it's not her job to do your job for you, but since you wouldn't shut up about it, I think she went ahead and gave you the scenario you were looking for. I'm going to guess that just like everything else so far, you'll produce 0 affidavits, you'll do 0 about it, and you'll just continue to bellow on in your statements about how Zellner's just completely out of line, but you won't offer anything to back yourself up. I think that's where this is all going to end up. So it's going to be interesting to watch the sparks fly on this one. Okay, so now we're going to move into where she basically jumps right into attacking the state's evidence against Stephen Avery as it sits currently at the moment, with her experts that have offered their affidavits and their expert opinions that have not been answered, have not been referred, have not been in any way, basically have just been avoided by the state. Completely avoided, like as if they aren't even there, like they don't exist. So she's bringing them up. And so here we go. And immediately we're going to jump right into attacking the evidence against Stephen Avery, the blood evidence particularly. So, the weakness of the forensic evidence used against Mr. Avery. The state has failed to dispute Mr. Avery's forensic experts' opinions about the weakness of the forensic evidence used to convict him. The following expert opinions have been expressed to a reasonable degree of scientific certainty. Mr. Avery's blood spatter expert, Stuart James, demonstrated that Mr. Avery's blood deposited in the RAV4 did not come from an actively bleeding cut on Mr. Avery's hand, but that it was purposefully distributed in some locations but not in others where it should have been, and if he was actively bleeding. It is not scientifically possible for Mr. Avery. It is not scientifically possible that Mr. Avery was actively bleeding from a cut finger, left no fingerprints but 6 drops of blood in the RAV4. That is a very small amount for an actively bleeding cut, supposedly. It does suggest that it was all that could be reclaimed from where the active bleeding was happening previous. Anyways, Mr. Avery's DNA expert, Dr. Cartwright, through a series of experiments with the RAV4 hood latch, has demonstrated that it would take approximately 90 attempts at opening the hood to deposit the amount of DNA recovered by the Wisconsin State Laboratory. Mr. Avery's theory is unrebutted that the hood-latch swab is actually a substituted groin swab taken from him at the Aurora Medical Center on November 9th of 2005. Dr. Reich also conducted experiments on an exemplar key. Mr. Avery held the exemplar key for 12 minutes and left 10 times less DNA than the Wisconsin State Crime Laboratory determined was present on the RAV4 key they discovered in Mr. Avery's residence. Dr. Reich was unable to perform an experiment in which two people had touched the exemplar key, but only one profile was detected. The bullet FL was found in Mr. Avery's garage with Miss Halbach's DNA on it. It has been refuted as being the bullet that entered Miss Halbach's skull, causing her death. Mr. Avery's trace expert, Dr. Christopher Palahniuk, and ballistics expert, Mr. Lucien Haag, have determined that #FL did not have bone particles embedded in it, as it would have done if it had been fired through Miss Halbach's skull. Dr. Palahniuk also discovered that there were wood and red droplet deposits in FL's surface. The red droplets were identified as blood by the state's forensic analysis, Sherry Culhane. Dr. Palahniuk also noted that FL had a waxy deposit on it. Current post-conviction counsel notes that investigator Wiegert on November 6th of 2005 requested that items be obtained from Miss Halbach's residence that might contain her DNA. Among those items, investigator Wiegert specified chapstick and possibly a vibrator. Those items, including the chapstick, were collected from Miss Halbach's residence and put into a sealed plastic bag. Inexplicably, on November 8th of 2005, Deputy Jeremy Hawkins documented that the toothbrush and the chapstick of Miss Halbach's residence, property tag #7096, were at the Avery property and repackaged into paper bags for transport to the Wisconsin State Crime Lab. Interesting. Very interesting. Why would they be moving from Ziploc baggies into paper baggies, and why were they at the Avery residence on the 8th? I'd love to hear the answers to those questions. Forensic evidence against Mr. Avery was not vast, overwhelming, and damning. Mr. Avery's jury was out for 3 days, not 3 hours, and he was acquitted of the mutilation charge, which was based on allegations that he had burned Miss Halbach's body in his burn pit. All right, so this next bit's going to be to, number one, clarify to the state, because they have made a misassumption about what she's looking for. She's making it very clear to the state that what she wants is nothing after February 5th when the trial started. What she wants is the 280 days that are after basically April 21st of 2006, and between that date and then February 5, the first day of the trial. She's talking about those 280 days that they went back in, obviously, and looked at. And she's talking about she wants the computer data from that, because that is leading up to Stephen Avery's trial, and it wasn't previously available till now, until they went back in there and got those, because they had turned the computer back over to Barb, so they didn't have any of the information of what was that computer was being used for between April 21st of 2006 and February 5th of 2007. So that's what she's saying. She's like, okay, that seems like relevant information. It's leading up to Stephen's trial. That's what we're looking for. And apparently the state was trying to suggest that she was looking for more than that, like after the trial date. After like February 5th when the trial started, like as if she was asking for things like after that and stuff. So she's just clearing it up here, going, wait, no. I just want what was, pertinent before trial, right? And then she moves on to explain that the way the state in their little six-page memo relied on O'Brien as the standard for why, Kathleen Zellner should be denied this forensic evidence, basically. And so she says here, she basically explains why she believes O'Brien doesn't exactly apply here, in the sense that they're going through an in-camera review. This is what Casey's asking for, is an in-camera review. And that's different, because that means that it's not asking the evidence to just be brought out right in court for everybody to see. What it is it requires the judge to look at the evidence first before and look at it and see if whether or not the defense should be, or well, in this case, whether or not the defense should be entitled to it. Sometimes it's information that comes in that the judge has to go through and decide what the prosecution and the defense can use in court, similar to a couple things in the OJ trial, which you'll hear me explain. And so sometimes it's information that comes in, but this time it happens to be information that the prosecution has, and she's thinking, well, we should be able to see what's going on there because it's, in that 280-day period before Stephen Avery's trial, so there's likely to be, some more of the same stuff we were seeing in the 180 days that we already have. So that's what she's basically getting at. Okay, so now we're going to move into why she's saying that the state's claim that she has no right to the new computer evidence, forensic evidence generated in the 2017 and 18 examination of it is, she's not entitled to it. Essentially, here she comes back firing. She's going to be talking about why, number one, why her just on the surface basic reason why it should be available. Then she goes into discussing why the state relying on O'Brien as strongly as they did in their little 6-page, well, we'll just call it a memo. But anyways, they were relying on O'Brien pretty heavily in there. So she's going to basically address that here. So first off, just her basic, observation here of why this would obviously be pertinent to what's going on. Anyways, the state contends that since any new analysis or re-examination constitutes evidence that did not exist at the time of the defendant's trial, it could not be consequential. It could not have changed the outcome. The state totally and completely misses the point of Mr. Avery's argument by mistakenly assuming that Mr. Avery is seeking to compel production of the DASI computer data after the trial in March of 2007. Mr. Avery is not. He is seeking the evidence that existed on the DASI computer prior to his trial from May 6th of 2006 to February 5th of 2007. The 280 days before Mr. Avery's trial would most probably have produced hundreds more images of violent porn involving the torture, bondage, mutilation, and death of young females, some of whom would have borne a striking resemblance to Ms. Halbach. The recovered pornography in Detective Beeley's report only recovered 180 days, from October 9th of 2005 to April 21st of 2006. Because the state disclosed the 180 days of recovered pornography on the DASI CD to the current post-conviction counsel on April 17th of 2018, it has waived any argument that the balance of the 280 days of pretrial computer data from the second forensic examination conducted in 2017 and 18 should not be disclosed. Clearly, at the pretrial stage, all the computer data is consequential, and because it had a reasonable probability of undermining confidence in the outcome of Mr. Avery's trial by having produced evidence that established any motive requirement for Bobby. O'Brien is not the proper standard for an in-camera review. Because Mr. Avery is attempting to make a preliminary showing to compel an in-camera review by the circuit court, he should not be held to the O'Brien consequential evidence test for the determination by this court of whether to conduct an in-camera review. The court, in State v. Robinson, explained as such, the defendant's preliminary burden for seeking in-camera review must be less stringent than the test applied by the court during its in-camera inspection. The Robertson court stated, we therefore conclude that the O'Brien consequential evidence test should not be used to decide whether to conduct an in-camera review. Robertson involved a request for an in-camera inspection of psychiatric records in a post-conviction setting. The Robertson court determined if the first four factors of the newly discovered evidence test are met, the trial court should apply the O'Brien consequential evidence test to determine whether the material it reviews during its in-camera inspection should be disclosed to the defendant. The Robertson court articulated an in-camera review standard requiring that a defendant must set forth a specific factual basis demonstrating a reasonable likelihood that the records contained relevant information that is necessary to determine a determination of guilt or innocence and not merely cumulative to evidence already available to the defendant. The court is required to look at the existing evidence in light of the request for an in-camera review to determine whether the records will likely contain evidence that is independently probative to the defense. In this next part, she's going to be talking about how it's basically pretty obvious that, in accordance to what was found within the 180 days that they currently have on the CD and on the DVDs and wherever else, that it's, a reasonable inference that you would find more of the same in the 280 days that followed it leading up to Stephen's trial. And she's saying that this evidence is all very likely to meet the standard, and she's going to go through the steps of that standard right now, of what the evidence needs to meet. So she's basically just making the argument that there's really no reason why this evidence should be withheld. It's most likely, at least for an in-camera review, for the judge to go and look at it and make the determination, because it seems pretty reasonable that there's something there that's of probative value somehow. So we'll go ahead and move into that now. Similarly, Mr. Avery has submitted in his motion to supplement the contents of the CD from the Dassey computer of Detective Ely's forensic analysis of the Dassey computer up to April 21, 2006. The CD contains an abundance of relevant evidence that could have established motive for purposes of meeting Denny requirement and identifying a third-party suspect. There is no doubt that the additional 280 days of pretrial computer analysis performed by Detective Ely could reveal more relevant information that would greatly strengthen Mr. Avery's argument that Bobby Dassey met the requirements to be named as a third-party Denny suspect. If Bobby had been named as a Denny third-party suspect, there is no question that this evidence was necessary for determination of Mr. Avery's guilt or innocence. The second forensic examination of the Dassey computer is new evidence. It's obvious that the second forensic examination of the Dassey computer would cover the 280 days pre-trial that were not previously examined. The first examination covered the time period up to April 21st of 2006. The second examination would have covered the time period from May 6th of 2006 until the beginning of Mr. Avery's trial in February 5th of 2007. The court considers 5 factors when deciding whether to grant a new trial in the interests of justice based on newly discovered evidence. State versus Benke. The 5 factors are: 1. The evidence must have come to the moving party's knowledge after trial. The party must not have been negligent in seeking to discover it. The evidence must be material. Okay, well, we know that Dean and Jerry issued 2 requests for all information and never got that CD. The evidence must have come to the moving party's knowledge after trial, which it was just handed over last year, so that's beyond a doubt. The evidence must be material. Oh, well, I think it is pretty much material. The evidence must not be merely cumulative, which it's not. It's completely new evidence that wasn't previously known. It must be reasonably probable that a different result would have been reached at trial or with a new trial. And I think this evidence has the severe tendency here to shake things up greatly. What is on that computer? It creates a lot of questions, a great many questions that need answering, which hence is the reason why we need an evidentiary hearing. So anyways, that's that. We'll move into the next ones. All right, so it looks like the standard to make the in-camera review is less stringent than the actual standards for reviewing the in-camera during the inspection. So what she's saying is it shouldn't be that hard to get. It's basically easier to get the in-camera review. But yes, the standard with which the judge uses to inspect the whatever the piece of evidence is, or the information is, the judge uses the strict O'Brien standard in inspecting it. But for the judge to at least be able to take a look at it in camera review, it's just a little less stringent standard. Anyways, so now we're going to move into basically the sum up. The very last few paragraphs of what Kathleen Zellner is saying here, and we'll come on back. So to wrap up, she's going to wrap up with this. The second forensic examination of the Dassey computer has discovered information connected directly to Miss Halbach's murder that has never been disclosed previously. The state's interview of Bobby that was conducted on November 17th of 2017, 7 days after the Dassey computer was taken on November 10th of 2017 by law enforcement for a second examination by Detective Veely, reveals that the state has discovered new information as a result of the second forensic examination that is directly relevant to Ms. Halbach's murder. Bobby was asked if he knew who created the folder with a page depicting Stephen and Teresa's photographs. Bobby indicated he knew how to create folders, but had no idea as to who created those folders. Bobby was specifically asked who created Teresa and Halbach and DNA folders that were on the computer, and he stated that he had no idea who did this. Bobby was asked if he did it, and he indicated no. The information about the existence of folders for Teresa, Halbach, and DNA is completely new information that is not contained in the CD disclosed to current post-conviction counsel on April 17th of 2018. Obviously, the information in the folders about Ms. Halbach and DNA is material. After this court's in-camera examination of the material should be provided to current post-conviction counsel so that Mr. Avery can establish with reasonable probability that a different outcome would have resulted at his trial if this evidence had been disclosed to his previous counsel. Clearly, the evidence is consequential only if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. Therefore, the court should conduct an in-camera review of the state's second forensic examination of the Dassey computer, grant Mr. Avery's motion to compel production of recent examination of the Dassey computer, conduct an evidentiary hearing regarding the results of this examination, and grant Mr. Avery's motions for post-conviction relief and to supplement the previously filed motion for post-conviction relief. Signed, Kathleen Zellner and Stephen G. Richards, of course. And that's the end of that one. All right. So, some interesting stuff there today, folks. That's basically that's the end of the whole, back and forth for the motion to compel. Zellner filed the motion to compel, the state responded, and now Zellner has replied to that response. So now we're going to wait and see what happens with Judge Sukowicz and what Judge Sukowicz decides. I think there's reason for her to do this in-camera review. I think she's in order for her to try to shake the whole tainted thing about Manitowoc. She really needs to be look like she's doing the fair thing. If she looks like she's doing more of the same we've seen from all the other agents of Wisconsin so far, then it's going to look dirty or strange. So I think it's the best way for her to go is to start, to do this in-camera review, look and see what was there in that 280 days leading up to Stephen's trial. And not only that, but in terms of the CD itself, there's a lot of unanswered questions here, and looks so freaking obvious that the state was just playing games here. They were, very much trying to just fly this evidence under the radar, but look like they were being straightforward and giving it over. It's just such a mess. And the state just continues to act like there's nothing wrong, just like they've done with everything else. Even when Stephen got out, after what they did to him in '85, when he gets out from that, there's no sense of responsibility when it comes to the agents of the state of Wisconsin. So it's just more of that going on, from the way I look at it here, folks. So anyway, that's about it for today. If you haven't already, please hit subscribe, and we'll see you.